This man spent only 3 days substitute teaching at a Florida high school, and somehow in that time still managed to allegedly have sex with a student at the school. When investigators started looking into this tip, they realized this teacher was already under investigation in a nearby county for an alleged relationship with a different student. I'm Gillespie, and this is Law&Crime News. It's a disturbing story we're digging into today out of Hillsborough County, Florida. That's where 39-year-old Joseph Prevatte worked as a substitute teacher for a few days this fall. Between October 1st and 3rd, he subbed at Leonard High School in Ruskin, Florida. According to the Hillsborough County Sheriff's Office, investigators found inappropriate messages between Prevatte and a student. Through the investigation, they also learned that Prevatte allegedly engaged in sexual interactions with a student at the school. The Hillsborough County Sheriff's Office didn't specify what exactly those sexual interactions were, but they were enough to warrant a charge for Prevatte. On November 18th, he was arrested and charged with harmful explicit communication to a minor, lewd or lascivious battery. So basically, he was allegedly sexting an underage student and had some sort of sex with them at the school. But during the investigation for this allegation, officials in Hillsborough County learned this wasn't the first time Prevatte was accused of sexual assault, specifically of a student. He'd also worked at Manatee County High School as a substitute teacher. That's only about 25 miles away from Leonard High. According to Manatee County investigators, Prevatte also sent inappropriate messages with a student there. He allegedly spoke with his victim for several weeks on Instagram and even included a picture of himself. In the pic, he wasn't wearing any clothes, but he cropped it to exclude his genitalia. All this came to light on October 31st when the Manatee County Sheriff's Office received a tip through Fortify FL. This is a really cool website in Florida. It's used to report suspicious activity to both law enforcement and school officials. Now, after this tip came in, Prevatte was charged with soliciting or engaging in lewd conduct with a student. He was booked into the Manatee County Jail on November 12th, but released on $75,000 bond. It was a week later when he was arrested and booked in Hillsborough County, and this time he's being held without bond. So there's a lot happening in this case. We've got to bring in former prosecutor and civil sex abuse attorney John Clune. Thank you so much for coming on with us today.
Oh, you're welcome. It's good to be here.
So what jumped out to me right away about this case is that we have a substitute teacher who was only there for 3 days. 3 days only, and still managed to have sex with one of the students, allegedly. What do you make of that right from the jump?
It's incredibly bold. I mean, most child sex offenders, there's a grooming period over, days, weeks, whatever, to be able to kind of break down some of those barriers for the kiddos, and for somebody to be able to move at this kind of speed with one of the students is pretty alarming.
Yeah, you mentioned grooming. That's something we talk about because, unfortunately, on Law and Crime, I've covered stories like this, honestly, dozens of times. It's something that we see a lot. And throughout it all, we see a lot of grooming. A teacher who knew the student for months, maybe even years, met with them after school. So they kind of build this relationship before they take it to the next level, so to speak. But in this case, how was he able to do all of this without grooming?
Well, it's a great question. There must have been some grooming on some level, even if it was accelerated. But it'd be really interesting to see the police reports on this one because it's an unusual fact pattern. I mean, the texting is a problem. I think that some of the offenders can, get access to kids, like have meetings outside of school because of these kind of secret, text messages. So that I'm sure helped in the facilitation of the crime. But it would be really interesting to hear the details of this because it's just an unusual amount of speed to be able to get sexual access to a kid like that.
Talking about texting or messaging, Instagram specifically was mentioned in one of the cases that he had slid into the DMs, was DMing with one of the students. To me, that sounds like a red flag right away. If your teacher is handing out his Instagram handle or his cell phone number, is that something that parents should keep an eye on? I mean, your child should not have your teacher's contact info.
Yeah, so this needs to be addressed from both ends, from both the parents and the school's side of this. I mean, there's no situation where, a teacher should be messaging with a student unless there are some apps that schools use that are on a platform where the schools have access to all the messages Maybe it's for like sports, coordinating, games, trips, that kind of thing. But other than that, there should never be this kind of messaging with students. So the schools need to emphasize it. But more importantly, if somebody's a sex offender in their school, they're not going to follow the policy. So the parents really need to teach this to the kids that there really cannot be any kind of messaging with a teacher. Any teacher that's messaging a kid outside of school, for anything other than what I just previously described, should be a red flag to kids that something's up.
Obviously, these messages are super inappropriate that are happening after school between the teacher and the student. But also, one of the allegations is that he actually had sex with a student at the school, which to me is incredibly brazen. I mean, people could walk in. Obviously, there's security cameras. What do you make of him deciding to go through with this illegal act right on school campus?
Yeah, I mean, we have to be careful not to convict him yet because he has been found guilty. But I will say that we see this on campus sexual abuse happen pretty. I wouldn't say regularly, but regularly enough with people who have done this many times before. So usually, somebody who is starting off their career as a sex offender is looking for more discreet opportunities and probably more prolonged grooming periods before they engage in that behavior. So if somebody did this in such a short fashion on campus, that's at least a signal that there may be, a significant history of abuse.
You're good to remind us that obviously these are just allegations at this point. He has not been convicted of any crime, which kind of leads into my next question about his defense. If we have some of these messages, on one instance, we have a photo of him, how is that something that he's going to combat in court?
It's going to be very difficult. Text messages these days, text messages, DMs, any kind of social media messages, they are making life very difficult for defense attorneys. I don't have a lot of sympathy for it, but I think that these messages can be very damning unless there's some way to explain the context of the messaging, which I can't imagine what that would be in this particular case, given what's been reported and the photo. It's going to be a very, very difficult thing. But one of the things that the main job for a defense attorney in this situation may be to figure out what is the best plea bargain that can be arranged for my client versus how do I convince a jury that he actually didn't do it. Or, you can have, there's two different charges in this case, and one of them is about the messaging, and the other one is about the actual sexual contact. Depending on what he actually says in these messages, there may be a defense of, well, I did the messaging, and that was wrong, but I didn't do the actual sexual contact.
So let's talk about the message because obviously this can be tracked down to his phone number and his username. We can determine that it is him. However, in one of the photos, we know that he took a pic of himself. It was inappropriate, but he had cropped it in a way so that he wasn't showing any of his genitalia, anything, I mean, obviously inappropriate. We have sexual undertones, but he wasn't showing anything illegal, so to speak. Is that something his defense would point out?
They will. It's an interesting from a legal standpoint. It's going to be an interesting question, like the fact that you blur out things like genitalia. Is that a defense to the lewd photograph communication? I don't know the answer to that. That's an interesting issue that I haven't seen before. I could see the prosecution say just because it's blurred doesn't mean he didn't commit the crime.
Another interesting aspect of this case is that it happened in multiple different counties. So, in Hillsborough County, when they started investigating this, they found out that to the county just south of them, in Manatee County, he had already been charged with a similar crime. This gets into prior bad acts. And I'm wondering if this is something that either county, when it goes to court, can mention, hey, he's also charged in the next county over for something that's kind of similar.
No, they'll certainly try. There's a provision specifically for this in the rules of evidence, and so they'll have to litigate that in front of the judge in advance of the trial of whether or not they get to use that other act. If it is, similar and goes to a particular issue in the case that's not just to prove that he's a bad guy, then there's a good chance that they would be able to use it in trial.
Do you think that this shows some sort of pattern, the fact that he has these allegations from two different high schools in separate counties?
Yeah, and that's why the prosecution will want to try to use it in their case, as it does show a pattern of behavior. What you're not allowed to do is say, well, he did it in this other situation, so that means it's more likely that he did it in our situation as the prosecutor. But there are a number of reasons why you can use it, and that pattern can be extremely persuasive for a jury. It's also one of the reasons why the judges have to be very circumspect about whether they let in or not, because it is such persuasive evidence to a jury that it better be admitted for a good reason, or it could be an appeal issue.
That's a good point. It would probably show a pattern, so it'll be interesting to see whether it will be allowed in either of the courts. My next question is, it seems, at least based on these two allegations, we keep going around the word pattern, that he has a pattern or history of this. Is it possible now that additional students come forward and say, okay, yeah, he also was communicating with me and make additional allegations?
Yeah, we definitely see that happen a lot in these types of cases. And one thing that you have to keep in mind is that, most survivors of sexual abuse never disclose their abuse. It's incredibly embarrassing. They feel tremendous shame. And so even though this is coming to light now, a lot of kids still may be reluctant to come forward because of those reasons. But that said, it's not uncommon that you get if you have somebody who's a serial offender, which most child offenders are serial offenders, you get other students to come forward, particularly once you have two. If it's just one, it seems like who's going to be the next one, but when you have two and maybe three, then people feel a little bit more comfort, like there's a safety in numbers about coming forward. So it wouldn't surprise me, not only if people come forward, but if the law enforcement starts talking to schools about looking for other potential victims.
What's interesting about both these allegations is that they are child sex crimes. At least, I mean, they were students at both of the schools under age 18, so they're kids. I actually looked at this defendant's profile on social media, and he has kids of his own. So if he is convicted of these crimes, or one at least, and he has to register as a sex offender, does that make things more difficult? I mean, he's around children in that he has two kids of his own.
Yeah, and so that raises a couple of issues. And one of them is, social services is going to, like in the interim, like now, be looking at I'm sure a bond condition is no contact with children. The judge will have to decide whether or not that includes his own children. We do see some crossover behavior from people who offend on other children and also offending on their children. So that's something that both the court and social services is going to be concerned with. But as he, if he ends up with a conviction, and whether he goes to prison or gets probation and on parole, has some sort of sex offender treatment, he's going to have to kind of earn his way into, being able to parent again safely with those kids.
Talking about bond and conditions, the first time that he was arrested and charged, he was released on $75,000 bond. But then, as we know, he was arrested and charged again with a similar crime, and now he has no bond. Do you think that that was the correct decision?
I mean, I think that at least for now, it's a good decision. Committing a new sex offense while you're on bond for a sex offense is a massive red flag to the court. If there is a way that the court can feel like they are safely monitoring this individual while still protecting the community, they'll want to explore that as an option. But at least as an initial measure, I think that is the right decision.
Things like this are always really tough to talk about. But, John, thank you for coming on and kind of explaining it a bit more to us.
You're welcome. Thanks for having me on.
Anyone with more information about Joseph Prevatte's allegations or any survivors are asked to contact the Hillsborough or Manatee County Sheriff's offices. Reporting for Law&Crime, I'm Sierra Gillespie.